This is Scott Horton. I will be giving today's presentation on employee drug and alcohol issues. We have just made the webinar live for attendees to join. So if you are joining and hearing me, then that's great. I'm going to get started as scheduled in a few minutes once we've had a chance to let everyone get in. On this end, everything looks good. People are able to join. You, again, in addition to hearing my voice, should see the cover slide for today's presentation, Employee Drug and Alcohol Issues. In addition, there should be a chat room where you can type in questions that you have. We'll go over all of this in more detail at the scheduled start time once everyone has had a chance to get in. If you have any questions throughout the presentation, I encourage you to type them in as you have them. We do have a lot of people registered for this webinar, and they're still adding on. So thank you for being here. And we'll just be waiting another couple of minutes just to make sure everyone who is able to get here by the start time will not miss anything. Just before we get started officially, for those of you who have joined, if by any chance you experience any lagging or technical issues during the presentation, which hopefully won't happen, just consider whether there's any other applications on your device that you can close to free up resources, as this is obviously a streaming live presentation. Again, you should have the cover slide, Employee Drug and Alcohol Issues, and you should have access to a chat window where you can type in any questions you have that might arise. We'll go over that all again about 1 or 2 more minutes after we give everyone a chance to make sure they're logged in. Okay, I suspect we will have a couple more people still joining, but we seem to have leveled off for the moment. So hopefully everyone who was able to get here right at the beginning is in and not having any logistical issues. With that, my name again is Scott Horton. I am a partner with Gunnar Cook LLP, which is a law firm based in New York City. We also have international offices in Europe. My office is actually in Orchard Park, New York, just outside of Buffalo. The topic today is designed primarily for New York employers, though to the extent you are responsible for employees outside of New York, either in addition to New York employees or exclusively, many of the issues we address would apply in other jurisdictions as well. But again, there is going to be a focus on some New York specific information. You will get a copy of the slides by email tomorrow if you are registered, and if you attend the entirety of the presentation today, you will receive by email as well an attendance confirmation, which will provide you the information you need if you're seeking HRCI credits. This program is pre-approved for 1.25, so 1.25 HRCI credits. That means that the scheduled time is 1 hour and 15 minutes. That will include a question and answer at the end of the presentation. If some questions come in throughout the presentation and I'm able to answer them in the course of things, then I will, but typically we'll save most of the questions and answers for the end. And with the hour and 15-minute goal in mind, I always stay on to answer any questions that are still coming in. I will also, for those that are eager to get them, make the slides available for you to download at the end of the presentation if you don't want to wait until tomorrow to get the email that will link you to those as well. Only quick note that there's no attorney-client privilege in our communications through this webinar. So even if you are my client, if you have a very specific situation that you ask a question about, just be sensitive to whether you want others to hear that information or that the answer to your question. If not, then you can certainly follow up with me separately. But to the extent that it's a general enough question, your question is probably something that other people are wondering about and would be happy to hear the answer to. Okay, given that I guess it's 2024 and that we are focusing on New York, it is probably logical to start with a discussion of marijuana. Obviously, we're going to be talking about issues that pertain to drug and alcohol use by employees generally, but because of recent legal developments over the last decade, generally, marijuana has some special considerations. And just to help the other topics we're going to address, such as drug testing and policies and discipline arising from drug and alcohol issues, go more smoothly, we're going to cover the marijuana piece first and then build into the more general topics. So going all the way back to the beginning of 2016, the New York Compassionate Care Act has been in effect statewide. This is the law that established the medical marijuana program throughout the state. There are currently 120,000 certified medical marijuana patients. That number actually has declined in the past several months since the last time I had reason to reference it. So that is perhaps the peak vicinity of how many New Yorkers have decided to become certified for medical marijuana. It was increasing gradually, of course, over some time, but I think once, as we'll discuss in a moment, marijuana became legal recreationally throughout New York, there has been less need or impetus to go through the process of becoming certified for medical marijuana. That being said, the number of certified practitioners, people who are authorized to write prescriptions for medical marijuana, has still been generally ticking up by relatively small numbers over time at this point, and now sits at over 4,000 health providers throughout the state. The law has been amended some since 2016. Originally, there was a more limited number of conditions for which marijuana could be prescribed by the certified practitioners. but at this point is essentially available for any condition that is deemed clinically appropriate by the patient's healthcare provider. And again, that goes logically hand in hand to some extent with the legalization of marijuana generally in the state. So what protections do medical marijuana patients have? Again, these are of somewhat less relevance than they were originally, but the certified medical marijuana patient is deemed under the New York Human Rights Law to have a disability. Presumably they have a disability independent of the marijuana prescription because they must have had some condition for which they were being prescribed the marijuana. So it's arguable whether that really extends any new rights in hardly any cases. But nonetheless, therefore, these patients who have a disability have a right to reasonable accommodations, if necessary, to enable them to perform the essential functions of their job. They are protected from adverse employment action, including termination, for example, because of disability. And that includes they can't be disciplined, terminated, or otherwise adversely affected because they use medical marijuana. Again, these were bigger issues back before marijuana was generally legalized in the state. There is, however, even for medical marijuana patients, no protection for being impaired at work. So, notwithstanding the fact that these patients have a right to use marijuana for medicinal purposes, they wouldn't necessarily have the right to use it at work if it's going to result in impairment. We're going to get to impairment more generally in a couple of minutes because it's a bigger issue now, again, with the general legalization of marijuana use. Even for medical marijuana patients, and this will come back again similarly, employers are not required to act in any way that would violate federal law or jeopardize a federal contract or funding. So next we turn to the more recent legislation, the New York Marijuana Regulation and Taxation Act. I've written this word and the name of this act multiple times in multiple places and had it both auto-corrected and changed by other people. But the legitimate legal name of the legislation does spell marijuana with an H. I actually researched that at one point, and it goes into some real language issues in the crafting of marijuana laws going back many decades at this point. So yes, I'm aware that marijuana is popularly spelled with a J these days, but nonetheless, just so you know, the law does actually spell it with an H. The law was signed March 31st of 2021, so just about 3 years ago at this point. Of course, it legalized quote-unquote recreational marijuana use with some limits. So really recreational use meaning that it's not limited to medical marijuana use. People can use it essentially for any reason they want to, with the limits that we will go over. It does further add specific protections for employees who use marijuana outside of work. I think overall these points are pretty well understood by employers and those dealing with human resources and employee issues in the workplace. Generally there's familiarity with these issues, but we're going to go into some of the details which are not yet entirely well known by everyone, both employee and management alike. And there is a pervasive question that we will attempt to answer to the extent possible of whether it matters that marijuana is still illegal under federal law. So, of course, as pretty much everyone knows, marijuana is still a federally controlled substance. Notwithstanding that, there doesn't seem likely to have been too much federal crackdown on marijuana in New York State since it was legalized, just I think is the case in many other states where it has now been legalized recreationally. But there are instances where the federal status of marijuana raises questions in the employment context, and we'll talk about some of those. I'm not going to read this entire list with the details, but I have it here so you can reference it. These are the specific activities related to cannabis and marijuana that the marijuana legislation authorizes for New Yorkers 21 plus, or I guess anyone who is at that time in New York and age 21 or over. It allows possessing, purchasing, obtaining, etc., limited amounts of cannabis, marijuana products, transferring them to other people who are also 21 years old or older. You can use it by smoking it, ingesting or consuming cannabis or other forms of concentrated cannabis unless somehow otherwise specifically prohibited by state law. At least originally, the medical marijuana law did not allow patients to smoke marijuana, but now, of course, you can do that generally in New York. So a bunch of ways of saying the same things, but possessing, using, displaying, manufacturing, etc., cannabis paraphernalia or any marijuana paraphernalia. And then it allows assisting another person who's also 21 years of age or older to do any of these other lawful acts. At this point, I have not included on this slide the permissions related to growing one's own cannabis or selling cannabis. So certainly originally, while you were allowed to purchase or obtain cannabis, there was still a general prohibition on selling cannabis, which obviously creates a disconnect. And there are obviously many marijuana dispensaries active throughout New York State, some legally, some whose authorization to do so is a little more questionable. That's been subject to litigation and other things and is gradually getting resolved. There is also now proposed regulatory action governing the individual growing of marijuana in your home or at your home. And those regulations are probably going to be finalized at some point this year, at which point it will be legal for individuals 21 years or older to grow a limited amount of marijuana for their own use. Again, like with the medical marijuana, there were specific employee protections implemented through amendments here to New York Labor Law Section 201D. 201D is a long-standing provision of New York law that generally protects employees' off-duty use of lawful consumable products. Historically, this has included alcohol and tobacco. Sometimes originally this law was referred to as a smoker's rights law, which meant that employers generally couldn't prohibit employees from smoking. But there are exceptions that I'll mention in a second. But the bottom line here is the law now specifically includes the use of cannabis in accordance with state law. So any of those things that the previous slide said were legal, generally speaking, New York employers are now not allowed to use as the basis for adverse employment actions. The law protects employee use of these products, including marijuana and cannabis, outside of work hours, off the employer's premises, and without the use of the employer's equipment or property. So you can still prohibit employees from, to be blunt, smoking pot while at work, which would even include like outside on their otherwise smoke break. And you could prohibit them from doing it, for example, in vehicles that are owned or maintained by the company. What you generally can't do is say when they're outside of work and off premises and not using any company property that they can't generally use cannabis products such as marijuana. Of course, like any good law, there are exceptions. These are the same exceptions in most respects that pertain to alcohol and tobacco use, but there is a specific addition for, again, referencing cannabis. So anything that the employer is required to do by state or federal law, they could still do, notwithstanding Section 201D. The employer is also allowed to take any appropriate action when the employee is impaired by the use of cannabis at work, or otherwise where the employer's actions would require such employer to commit any act that would cause the employer to be in violation of federal law or would result in the loss of federal contracts or federal funding. This is pretty similar to the first bullet here. Again, required by state or federal law. So, of course, one starting to wonder, okay, well, what is it that state and federal law and related issues allow employers to do that is otherwise prohibited? Well, before we come back to that more complicated question, it's important to note that, again, you are allowed to take action for employees who are impaired by marijuana at work. The problem becomes demonstrating impairment. The definition of impairment for this purpose is that the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position, or such specific articulable symptoms interfere with an employer's obligation to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. Yep. Just before I move on, there is guidance from New York State's Department of Labor on this impairment topic, which unfortunately really calls into question what specific articulable symptoms would sufficiently demonstrate impairment. One thing that the state is clear is that a positive drug test for marijuana would not constitute a specific articulable symptom of impairment because marijuana remains in the system for so long, generally assumed to be much longer than the impairment period. In fact, the New York Department of Labor, as we'll talk about further, has said in essence that in almost all cases, New York employers are not even supposed to be testing for marijuana. But certainly if they do test and find a positive marijuana test, there is generally nothing that employers may lawfully do with that information. The Department of Labor guidance goes on to say that specific articulable symptoms also don't include things like smelling of marijuana, because, of course, one could easily smell of marijuana in an environment where marijuana use is legal, whether or not that person has recently partaken in marijuana themselves and whether or not they are, as a result, currently impaired. Getting back to the now dicier question in the sense that it's basically the only real exception to the general protection of employees using marijuana is the issue of what does federal law require. For better or worse, I guess depending on your perspective, federal law doesn't generally prohibit any employers from employing medical marijuana users. That is further true regarding recreational marijuana use as well. The real limited nature of any federal requirements per se is based on some safety sensitive transportation positions that are subject to federal regulations that require drug testing in various circumstances, and the controlled substances by federal statute include marijuana. So if you are in the transportation industry and have people driving certain types of vehicles for commercial purposes, then the drivers and the mechanics and certain other safety sensitive positions connected to those transportation activities may subject those employees to federal requirements, including mandatory drug testing in certain circumstances. And there you certainly could test for marijuana, probably have to test for marijuana to be compliant federally, and then could presumably take the necessary corrective actions that could include discipline, including termination where there has been marijuana use. Because most of the attendees for this webinar do not fit into that category, we are not going to go into those requirements in too much specific detail, but we will talk about those regulations a little bit more when we get to the drug testing piece. There is otherwise something called the Drug-Free Workplace Act, which since medical marijuana was first permitted has become a topic of discussion. The law itself does apply to employers with a federal contract worth more than $100,000 or a federal grant, which is a relatively sizable portion of the business organizations out there. So there was an initial thought that based on the exceptions to these laws, that employers who are subject to the Drug-Free Workplace Act could still prohibit their employees from using marijuana, whether for medicinal purposes or recreationally. However, when you really get into the details of the Drug-Free Workplace Act, there are a comparatively limited number of actual requirements related to the law. Covered employers must adopt a drug-free workplace policy and establish a drug-free awareness program. However, the law clearly does not require any employees to either test for drugs or to fire or otherwise discipline employees who use drugs. In that sense, for example, there is not a direct exception to the 201D protections employees who use marijuana have, because, again, the federal law does not require any adverse action based on drug use. What it further requires under this federal law is that employees who notify or must notify their employer within 5 days if they're convicted of a criminal drug violation, but not just any criminal drug violation, a criminal drug violation arising out of the workplace. So, for example, if an employee is arrested for illegal drug use or distribution at work, then that employee must notify their employer within 5 days if the employer is subject to the Drug-Free Workplace Act. And then in that scenario, the employer must notify its contracting or granting agency of this employee violation and somehow penalize employees who violate the policy. Again, there's nothing specifying what those penalties need to be. Therefore, using marijuana, whether it leads to a criminal conviction in some way, shape, or form, or otherwise, is not something that requires that the employee be disciplined, much less fired, even under this Drug-Free Workplace Act. Therefore, accordingly, it's unlikely alone to create an exception for the general protections under Section 201D. Separate and apart from discipline, the Drug-Free Workplace Act certainly allows that the penalties could include requiring participation in drug abuse awareness or rehabilitation programs, which we'll talk about again later in connection with the concept of discipline generally. But again, on the whole, this federal law that is relatively widely applicable probably doesn't create any exceptions to the general New York State protections of employees who use marijuana outside of work. Okay, with that background on the special case of marijuana, which we're going to need to reference as we go forward on these other topics, I'm going to now turn to drug testing. So for drug testing, there are various legal considerations. The one I wanted to mention first is the field of disability discrimination. So it is clear and legally recognized that both alcohol and drug addiction can qualify as disabilities, both under the federal ADA, Americans with Disabilities Act, and the New York State Human Rights Law, and various other state and local disability discrimination laws as well. The primary distinction for drug addiction is that the protection is in essence limited to prior drug addiction, not that someone's drug addiction is necessarily gone away, but the protection does not continue if the employee has illegally used drugs recently or at present. So while the law says you can't discriminate again, and in some cases may have to accommodate alcoholics and drug addicts, the clearest exception to that is in the case where someone has recently used illegal drugs, and that's what you are disciplining them for. In other words, you don't have to tolerate the use of illegal drugs just because someone is a drug addict. Of course, as we just discussed at more length, marijuana creates a conflict between state and federal laws in New York in particular, of course, as well as the other states where marijuana is legalized. So under the ADA, arguably marijuana use and addiction, for example, would not qualify as a disability, but that's not too practically relevant throughout New York State, where the human rights law is generally broader anyway, and certainly would recognize marijuana addiction as a legal use of a drug, as just discussed. So beyond the general discrimination, disability types of considerations, we then wonder what other legal parameters are in place. So there are no direct restrictions on drug testing most employees in the private sector. So that means that if you are an employer in the private sector, you generally would have the right to drug test employees. Now, that doesn't mean you can do anything you want by way of drug testing, but it means that the concept is generally available to you. This could include the various different forms of drug testing, which we will talk about in a moment. Then we start to wonder, okay, well, what other possible limitations could get added onto the situation? Well, if you have a union, one way or the other, drug testing for existing employees becomes a mandatory subject of bargaining. So if you want to have post-accident or random drug testing of unionized employees, that would have to be negotiated. In most cases with the union, there's typically a recognized distinction for pre-employment drug testing because before someone is hired, they are not represented by the union. Then in the public sector, again, including New York public employers, but potentially other states as well, to the extent that's relevant to anybody, there are recognized constitutional limitations on drug testing based on protections, for example, for search and seizure and privacy rights and those sorts of things that come through the public sector under the state or federal constitutions. That does not mean you can't drug test in the public sector. Of course, in New York, most employees that are likely to be under consideration for any form of drug testing in the public sector are likely to be unionized as well, in which case, again, the bargaining issues come into play, and the bargaining issues help resolve some of the constitutional issues. And I'm not going to get too much in detail on that. There's not absolutely clear-cut lines on all of that, just to recognize that if you are in those situations, there are potential limitations on what you can do and how you can do it. And then, as I alluded to before, there are statutory requirements for some safety-sensitive functions under Department of Transportation and other regulations. Now, that regulatory scheme is fairly complicated because within the scope of the Department of Transportation, there are various agencies, including, for example, the FAA, and different agencies have different regulations and they cross-reference each other and circle back on each other. But we can at least identify the general principles. It's just that depending on what specific aspect of transportation you're in, you may be looking at, in part, separate regulations than others that probably ultimately get to about the same principles, but can vary in some ways. So generally, the Omnibus Transportation Employees Testing Act is a federal law requiring drug and alcohol testing for certain transportation employees, which is likely to include, most commonly, pilots, bus and truck drivers, and certain mechanics. Again, when you're talking about any of these types of positions, it's going to depend on the nature of the business entity. Pilots, for example, could get more complicated. Certainly, if we're talking about commercial airline pilots, the law is going to apply. If you're talking about independent type or small pilot that doesn't have any people or significant cargo on their plane, but are somehow flying related to business, the requirement may not apply in some cases. Similarly, for bus and truck drivers, there's some distinction based on what they're transporting, how many people or what weight of items or vehicles they're using. And again, across a certain threshold, those employees are going to be subject to drug testing requirements. And then the mechanics that work on the vehicles whose operators are otherwise covered, as well as other safety sensitive positions in connection with those operations, which again can vary by agency, could also be subject to certain drug testing requirements. As I alluded to before, various federal agencies under the Department of Transportation have separate, in some cases, but extensive drug testing regulations that are similar but not necessarily identical. The big upshot of all of this is that because there is this robust federal drug testing regime under this Omnibus Transportation Employees Testing Act, the standard principles and procedures of these federal regulations are often relied on in unregulated industries as well as a model for effective testing procedures. So hypothetically, if you're in the retail industry operating stores, you don't have federal regulations that tell you how to drug test your employees. But if you want a good reference, it's easy to pull. Well, easy to pull, maybe not necessarily so easy to understand. They're pretty detailed, but at least you do have a detailed set of guidelines for good procedures, or at least federally approved procedures for employee drug testing. So again, they're often relied on. The components of these regulations, and as I said, items that are often copied even outside of the industries where they officially apply, relate to collection of the specimens, the laboratory testing procedures, and then a review process by a medical review officer. In most cases, if your business is contracting with a lab who regularly conducts employee drug testing, they are likely to be performing those tests and following procedures that are more or less in line with what the federal regulations establish for the transportation industry. But again, you may not, strictly speaking, be subject to all of those requirements, but it basically becomes a best practice type of scenario. I mean, to be completely hyperbolic about it, there's not necessarily a law that would stop an employer from having their own lab test, an employee specimen, blood, urine, or hair, for example, in some cases, and saying, okay, we think you tested positive for this. But that's probably not generally going to be the best practice unless, for whatever reason, your company itself is in the business of conducting sound drug tests. These types of testing, again, are found in those federal regulations and often borrowed in the workplace, generally outside of those industries as well. There are pre-employment tests, random tests, periodic tests, reasonable suspicion tests, and post-accident tests. So pre-employment tests are pretty self-evident. They're done in a lot of workplaces, but of course not all. Before someone starts working, they are offered a job contingent on passing a pre-employment drug screening. They have the drug test. The results come back, ideally through a medical review officer, and say, this person tested positive or this person is clean. Again, in New York now, that generally shouldn't be including testing for marijuana, but if by chance there is marijuana on the panel that comes back positive, certainly shouldn't be used as the basis for not hiring someone unless you are in one of these federally regulated transportation fields. Again, generally speaking, all of these tests are required in certain circumstances for those transportation industry covered employees. The random drug testing, again, is like it says, we're going to subject someone for various reasons to testing on a random basis. This could be a pool that's tested, or in some cases, an individual could be specifically subject to ongoing random testing. That would usually be the case only if they've already previously tested positive. The periodic testing is a little different than random because, random mean at some unpredetermined time. Periodic might mean that employees are subject to retesting every 6 months or year, 2 years, or something like that. I guess it doesn't necessarily have to be on an absolute scheduled basis. There could still be some degree of randomness there, but the key distinction being that overall, that your workforce on the whole is being subject to testing on a regular enough basis. Reasonable suspicion testing is what you might otherwise be inclined to do when you think an employee has been impaired at work based on some articulable symptoms. Historically, this would include, I believe, things like smelling of marijuana, having bloodshot eyes, and potentially engaging in dangerous or unusual behavior. Obviously now, as I noted, not only does smelling of marijuana not constitute grounds to believe someone is impaired by marijuana, you of course couldn't test for marijuana anyway in that scenario. Again, with the key exception of these transportation positions. The post-accident test is, in a sense, a subset of reasonable suspicion testing. And that is that if someone has an accident at work, then you could be testing to see if some illegal drug use contributed to the accident or alcohol contributed to the accident. So in a sense, the accident itself creates the reasonable suspicion, but the post-accident testing regime could be in place potentially, whether there's any suspicion or not, just as a routine matter, of course, to make sure that there wasn't some drug or alcohol use that contributed. There's been issues discussed through OSHA, the Occupational Safety and Health Administration, and the underlying act, as to whether post-accident testing is allowed. There was a time where there was some regulation that suggested that it might not be appropriate to have post-accident testing without some further reasonable suspicion. But generally speaking, right now, I don't think there's a direct prohibition on doing post-accident testing. Of course, again, the transportation industry aside, where everyone is subject to these if they're in certain positions, in other unregulated industries and jobs, you certainly would not want to be discriminating in your application of drug testing, whether that be based on race, sex, age, any other protected characteristic, or just some other ad hoc basis that, lo and behold, could, at the end of the day, give the appearance of discrimination based on some protected basis. So you would want to have justification for why the people being tested are being tested. Often that would mean you want to be testing everyone who seeks a certain job, not just some of the applicants that you're otherwise offering employment to. When you're doing random testing, obviously it should really be random and not, systematically over testing certain demographic groups. And likewise with any of these, if you're going to do post-accident testing, you should do it after every accident or have some other criteria, such as certain types of accidents or certain types of accidents where there's also this other factor or factors involved, which might, again, lead to a reasonable suspicion situation. Of course, if you're doing enough of this testing, you should be able to do some statistical review to make sure that you're not discriminating on any of these bases. If you rarely ever do drug testing and only have a couple instances where it's been necessary, then it's harder to argue one way or the other whether there's any discriminatory intent or impact. Okay, now that we have the foundation of the drug testing regime in place, we're going to move on to discussing policies. And then once we get built up with the policy issues, we are going to get into some discipline issues. I think we're doing really well on time here. Again, if you have any questions, enter them as you have them. So I can't give you a drug testing policy if for no other reason than it's going to depend. Obviously, there's no one size fits all. If you're in one of these regulated industries, then your drug testing policy should, of course, match the regulations, but you still would have different specific circumstances in which positions there are that you have and those types of things. In other workplaces, you're gonna want to test for certain things. You're not going to want to test for other things. You're going to want to test in certain situations. You're not going to want to test in other certain situations. So again, the first question, the bright line is there a federal requirement one way or the other, whether it's for testing, discipline, what have you? There are not that many federal requirements at the end of the day. There is the Drug-Free Workplace Act and there are the transportation regulations. So if you are subject to the Drug-Free Workplace Act, you do need to have a policy and a program about maintaining a drug-free workplace. Again, that doesn't necessarily mean a policy that says if you test positive for drug use while you're working here, you're going to automatically be fired. It doesn't allow you to do that in the case of marijuana, most likely. But you do need to have some sort of policy. You can, build that in. It's not unusual to have a drug-free workplace statement, whether you're subject to the Drug-Free Workplace Act or not. But obviously, if you are, then you're required to have such a statement in place. But again, even with that, if you're subject to the federal requirements, you have a great deal of latitude in how your policy is written, what it allows, what it prohibits, what it permits, etc. The next bullet I have on this slide, the nature of jobs and the workplace expectations, is a relevant factor, of course, in almost all cases. There are just some jobs for which you're going to have more concern about employee drug use than others. If they're working with, expensive and or potentially dangerous machinery, then any impairment could have more devastating consequences than individuals, for example, who only sit at a desk and talk on the phone. Not to say that employees who sit at the desk and talk on the phone should generally be permitted to use drugs, or for that matter, frankly, to say that they shouldn't be. But there are different considerations based on the nature of your workplace, and that makes sense. Within an industry or company or whatever, it would be reasonable to understand, for example, that if you have, just to follow the scenario, a call center and a a warehouse, that you might be testing your warehouse employees and not testing your call center employees. And that wouldn't necessarily be discriminatory or otherwise problematic, because it's based on a legitimate business factor. Obviously, these same considerations play into drug testing. The drug testing issues, probably end up depending more on company preference than on any legal requirements, except, again, in the transportation industry. But then if you want to have drug testing, you don't have to have the full array of drug testing. You can just do pre-employment drug testing. You can only do random drug testing of employees who've otherwise had a discipline issue related to drug or alcohol use. And you can set up the details of those procedures on a specific case-by-case basis. Again, assuming you're not being discriminatory based on some other form of protected characteristic. Another factor that I add here, because I've run into it many times, is the issue of labor supply. There seem to be jobs, industries, locations, etc., where drug testing, whether it be pre-employment drug testing or during employment drug testing, and depending on which drugs you're testing for, the practice of testing can reduce the availability of potential employees. I think, in my experience, this has mostly been an issue before marijuana became legally protected. So, there were issues where employers were struggling to find employees who could pass a marijuana screen, which now is no longer an issue because, again, if it's not a regulated transportation job, then you can't screen employees based on marijuana use anyway in New York any longer. But if for whatever reason, at the end of the day, the only way you can have enough employees is to not engage in drug testing, then that's a business decision that has to be made and weighed against other factors, principally including safety, damage to equipment, etc. Finally, the issue of enforcement gets to the question of, okay, we're going to have policies. I mean, virtually every employer has some form of drug and or alcohol policy. If nothing else, they say you can't be impaired at work. The issue of impairment, except where required for marijuana as a statutory matter, is a dicey one. Generally, historically, there have been reasons to write your policy to say not necessarily impairment, but maybe impairment and or interference with performance of the job, and or ideally any detection of the presence of a controlled substance in your body. That you wouldn't use that wording exactly while at work. If someone is tested or for other reasons you can prove that they had cocaine in their system, then there's nothing generally stopping you from disciplining them, whether they were quote unquote impaired or not. And again, assuming you're not otherwise discriminating. Anyway, so those types of issues ultimately usually culminate in a policy statement of any violations of this policy will result in discipline up to and including termination of employment. You can go to more or less detail. The federal regulations for the transportation industry, have detailed sets of procedures that if you pass this test or fail this test, you have to retest. And then after this failed test, if you fail another test within this amount of time, then, you can't work any longer in this job or something, to that magnitude. So again, if you want to set up regimes like that are otherwise non-discriminatory, you can, but in many workplaces, it's sufficient to have more generalized statements. Obviously, if you're going to have detailed, periodic, and random drug testing requirements, you would want to have written procedures, and probably in that situation, you're more likely to have specific consequences. So again, just to pinpoint and finalize the topics I was just discussing, what do you actually see in your policy? Well, you're going to say the following are prohibited, or the company prohibits the following, or if you do any of these things, you're going to get in trouble. So however that is written, the key point in New York now is in most cases that shouldn't include a reference to marijuana, whether you use the term controlled substance, illegal drug use, whatever it is, you're okay probably, as long as you don't, either by reference to federal statute or by specifically identifying drugs, reference marijuana. You can generally have your policy written to say illegal drugs without worrying about, well, is somebody going to misconstrue this to include marijuana because it's, illegal under federal law. I wouldn't worry too much about that detail, but I wouldn't say controlled substance and then reference federal schedules where marijuana and cannabis would be listed. Then you might also have permissible uses. For example, alcohol is something that in reality is tolerated in connection with employment in certain circumstances. Not generally as a routine matter on your day-to-day job performance, but if nothing else, perhaps at firm, company, organizational events. Whether that's generally advisable or not is a different topic, but to the extent that it's going to be allowed in the office for certain holiday parties, etc., or in connection with company events, you probably don't want your policy to otherwise state that would be impermissible. So if your policy says you cannot use or you cannot consume alcohol on company property, and then you host a holiday party on company property and serve alcohol, there's obviously some inconsistency there. I mean, presumably, hopefully, you're not serving illegal drugs at your holiday parties, so that's a different consideration. But, those are things you want to think about. Permissible use could also include the use of prescription medication, again, to the extent that hopefully no one is getting a prescription for something that's not an illegal drug. And marijuana, of course, whether they have a prescription for it or not, is no longer a specific concern because it's protected. Testing procedures, as I said, if you're going to do that, and then the consequences of violations, as I discussed before, could be a relatively generic statement or more specific. Okay, so our final topic, and then we'll answer questions, is discipline. This is the culmination of all the other issues we've discussed. We've mentioned discipline, termination multiple times already, but I want to bring it home with some key points and considerations. And those are what are listed on this slide principally. First, again, discrimination. Whatever you want to do, obviously, assuming you otherwise aren't directly prohibited from doing it, you need to make sure it's not going to be either discriminatory in intent or in impact. So employment discrimination laws prohibit both intentional discrimination and actions that may on their face not appear to be discriminatory but have a discriminatory impact. For example, if you had hypothetically a warehouse and you wanted to do random drug testing of just your night shift warehouse workers, but not your day shift warehouse workers, on its face, that's not necessarily discriminatory on any legally protected bases. There might be reasons why you have more concerns about what's going on at night than what's going on during the day. If, however, it turns out that some disproportionate distinction in the demographic makeup of your night shift employees versus your day shift employees means that you are now, more likely to be drug testing certain, minority age, sex groups or whatever, then that could become legally problematic, even if your intentions were good. For example, greater risk of damage. There's less supervision on the night shift. There's more theft that's been happening on the night shift, something like that. So not to say you couldn't make that distinction at the end of the day, but something to definitely keep in mind if there are other demographic distinctions that, if nothing else, could lead to allegations of discrimination. The discrimination issue also technically relates to the disability issues. So whenever you have an issue of someone who may be an alcoholic or a drug addict, that merits some consideration in what discipline is going to be imposed. If you are subject to strict regulations of what has to be done under certain situations, there are situations where positive tests or refused tests require that someone be removed from service for at least a certain period of time and or until they pass a return to duty test. But generally speaking, someone who is an alcoholic doesn't have the right to be intoxicated at work. Someone who has a history of drug addiction doesn't have the right to be illegally using drugs. But there are reasons why you would need to accommodate those individuals. For example, someone might need a job restructure if it's otherwise practical and not an undue hardship, because they need to attend rehab either all at once or on a periodic basis or whatever. So these are just factors that do come up and need to be considered. And you can't necessarily say to someone who normally has to go to a specific meeting related to an addiction every week at 4:00 on Wednesday, and you allow it, and then one week tell them if you don't show up if you're not here at 4:00, you're going to be fired. I mean, that obviously could cause a problem. The treatment piece here is, okay, we have someone who has done something that otherwise warrants or may warrant discipline, be it that they were drinking on the job, we found some illegal substance in their work area, or what have you, even a case where there's attendance issues that seem to be connected to alcohol use, which certainly comes up. One consideration is there treatment that may be available, may help this individual, and that may be whether or not it enables them to continue working there or not. So obviously many companies have EAP programs that allow for referrals on this basis. So these are always things you might want to consider, potentially even if you are disciplining up to and including terminating someone's employment. Just because they're no longer going to work for you doesn't necessarily mean you don't want them to get treatment, and that might be facilitated. But of course, it becomes a bigger issue in the scenario where you want to condition future employment on receiving some form of treatment, which can be done. I'm going to get to the last chance agreements in a minute, which often involves that scenario. But most of that is available with the understanding that once someone is going to treatment for these types of issues, that then becomes a disability issue that may require both that you don't discriminate on that basis and that you provide accommodations. So these decisions get complicated just as many other disability issues do. I put this at will versus cause piece in there because it has a few different implications. So whenever we're talking about discipline, of course, in New York, like virtually all states in the US, there is a default concept of at will employment. If you are in the public sector, however, or in a union setting, there is often going to be a statutory or collective bargaining provision that provides some form of protection for cause or just cause discipline. So obviously you want to know that if someone shows up to work 5 minutes late and still smells of alcohol and they're purely at will, notwithstanding any other considerations, including discriminatory treatment, you probably can just fire that person if you want to because they're an at-will employee. On the other hand, whether you could fire that person and uphold it under a cause or just cause standard, is a different question. So those things have to get considered carefully. So make sure, of course, that you're always reviewing any applicable statutory provisions, collective bargaining agreements, or employment contracts, which can also have limitations on the ability to terminate or discipline an employee. Finally, all that being said, we get up to the last comment that I wanted to address, and then I'll ask again for any questions and answer any that are coming in, is the idea of a last chance agreement. Now, this is a common name for these types of arrangements, but certainly no magic to the term last chance agreement. It's not a statutory concept or anything like that. And by the same token, last chance agreements are not limited to drug and alcohol situations, but they are common to them overall. I have worked with many different employers across many different industries on various drug and alcohol related circumstances that result in an agreement that I would lump into this category called last chance agreement. And basically what it is an agreement, sometimes because there's a union involved and there would have to be a discipline leading to potential grievance and arbitration, and that one needs to be resolved or what have you. Sometimes just in a purely at-will employment situation, public or private sector alike, the idea is the employee acknowledges that they did something related, in this case, to drug or alcohol use, misuse, and that doing so again would have serious repercussions, likely meaning that they agree that if they're in violation of related requirements in the future, then their employment will be terminated, potentially without the ability to grieve it where that's the case, or otherwise with an acknowledgement that they wouldn't have the right to future employment if that happens. Now, these last chance agreements further also often have treatment requirements, or at least a referral to EAP or some referral for assessment. They can even include requirements that the employee authorize that any treating professionals provide certain information to the employer, which, if nothing else, is designed to allow the employer to get confirmation without HIPAA concerns that the person is actually doing whatever it is that they're supposed to be doing and receiving whatever treatment they're supposed to be receiving. So these documents are not unusual. They're not required in most situations by any form of law, but in most cases, they're not prohibited by any form of law either. So they are a potential option. And again, you could do it for any other form of discipline. If you get, caught falsifying documents again, if you get into another altercation with a coworker. But one of the reasons why they seem to come up so much with the last chance agreement, really, with a drug and alcohol issue, is really the concept of treatment, because in a lot of cases, other than a medical, underlying addiction / medical / disability issue, maybe the person wouldn't have gotten into this position. And, at the end of the day, people are good people, and we want people to get the help they need. And if they can get the help they need, we don't necessarily want them to lose their livelihood as a result of it. And last chance agreements can be a helpful way to facilitate all of that. Okay, with that being said, acknowledging that we both covered a lot and could have gone into more detail on various specific topics, I am done with my presentation and would be happy to answer any questions that come in. I think I have one or two in queue. You can either specifically click to ask a question, or you can just type it in the general chat, and I'll be looking at those. In just a second, I'm going to put up the link to the slides. Just a reminder, if you ask a question, I'm not going to be able to give a confidential answer here. So expect that other people are going to hear how I address your question and may see your question if you ask it in general chat. So now you should be getting the link to the slides if you want that. Further reminder, assuming you're registered for this webinar today, then you will receive an email tomorrow that also links you to those materials. And if you've attended throughout this presentation to this point, you will get the code you need for your HRCI credits for those of you who are certified in that regard. Again, emails tomorrow on that one. That email will also have, in addition to a link to the slides, a link to the replay or recorded version of this webinar as well. One question I do have in at this point is, what if the use of marijuana is immediately prior to the employee's work shift, but not on the property or during work action? Can action be taken if there is articulable impairment during work hours? The easy answer to that question is yes. If marijuana use causes impairment at work, then there can be discipline. The complexity there is they can't be disciplined for pre-work marijuana use, and they can't be tested for marijuana, or if they do, the test is not going to be acceptable as evidence of impairment. And therefore, the whole issue becomes, are they impaired by marijuana or not? And how do you prove that? Which really gets to the point of, what did they do that led them to be deemed impaired by marijuana. If they were just, wandering through the hallway with a dazed look, I suppose that, again, the impairment alone can justify discipline. The reality is most cases where any serious discipline is going to get taken probably involves some underlying conduct that in and of itself is problematic enough that there would be justifiable discipline. So where possible, it may be advisable to focus more on the underlying or associated conduct than it would on the mere fact of marijuana impairment, which will be hard to prove. To make this as tangible as possible, again, if you have a forklift accident and then as soon as everybody responds over to the accident, it becomes pretty clear that this person is impaired by something. And even assuming you are able to conclude, or the employee acknowledges that it was pre-work marijuana use, I wouldn't just say we're firing you because you used marijuana or you were impaired by marijuana at work. You would want to say that the discipline is because you had this accident, which was a result of your own, whatever it is, conduct, including the fact that you put yourself in this position where you weren't able to perform your job safely. In other words, let's worry about proving a marijuana impairment only if we have to. If we can otherwise show that you did something that warranted whatever consequences are being implemented, you may have an easier time if and when you ever have to prove that. I actually think that's the only question that I hadn't already answered in going through the materials originally. So if anyone else has any further questions, please type them in. I mean, we have finished our time otherwise, so I understand if anyone needs to go, but happy to answer any more questions. If you're concerned that you can't get your whole question in, submit whatever you have. I'm going to try to make sure everyone has ample time before I just close out the webinar. In the meantime, while anyone else is thinking about if they have any questions, I just thank you all again for participating. Reminder to look for the email if for some reason, especially if you need the HRCI credit or you haven't already downloaded the slides or what have you. If you don't get the email that you should get tomorrow afternoon, then let me know. We can certainly get you that information if there's any problem. Otherwise, if you have other follow-up questions, my contact information, of course, is on the screen. But at this point, I don't see any further questions. There's still a good number of you on. I think a lot of people are waiting to hope somebody else is going to ask a great question. But it's hard for me to guess what your questions would be. So I'll just give it another 30 seconds or so. If I don't see anything else, then we will go ahead and close up. Okay, well, barring anything else coming in right now, I don't have any more questions. Hopefully this information was all helpful, gave you enough to think about and go back, and whether you're reviewing your existing policies, thinking about procedures that you want to look into possibly changing going forward, or just some information related to the latest on the whole marijuana issue, Hopefully there's some good takeaways that you were able to get out of this, and look forward to letting you know about these webinars going forward. Try to do one every month or so on average. I don't have a next one scheduled as of right now, but expect one in probably sometime in March, and if not in March, certainly by April. If you have any requests for specific topics, you can always let me know that as well at the contact information on your screen. With all that being said, thanks again, and I am going to go ahead and close out today's webinar.